But other folks got a minute or two, so I'll let some other folks get on. Meantime, let's see here. Try to operate my computer well. It's been an exciting computer day for me. I haven't nearly thought that I had some kind of virus and shut down the whole OUHSC campus, only to find out that I really didn't, which was good. Kelsey was excited about that too. So, hey, Susie, how are you?
Very good, thank you.
I can't hear you.
Oh.
All right, let me, I'm going to go ahead and I'm going to be sharing my screen a lot today. Let me go ahead and share it. I want to go over, let me see. Kelsey, are we ready to go? Is everything good?
Yep.
All right.
Please be good.
We'll take off, see where we land. All right. So, so we'll go ahead and share my screen. And get that kind of good. So here's what we got coming for chemical dependency sonar in December. I'm going to talk with you today about ethical principles and practice. And then next week, Raina Leckie is going to talk with us about mindfulness and substance abuse treatment. She's now down in Norman at the school there. She used to be faculty here. So we look forward to that. And then on the 16th, this will be kind of a different presentation for us, but one that I think will be good. Myself and Dr. Stephen Crawford, who's Associate Dean for Community Practice, and as past chair of the Department of Family Medicine, we're gonna do a co-presentation. And we're going to talk with you about harm reduction, and this is a program that he heads up to put harm reduction expert programs in primary care practices across the state of Oklahoma. We did a presentation on that not too long ago and thought it would be a good one for this group as well. As many of you may know folks who are in primary care who would benefit from a program like that, and or you may actually work out of a family practice federally funded community health center. So so we'll take a look at that. Then we'll be on break until, actually I think we're on break until probably to the first week of January, but we'll try to get the January schedule out before we break on the 16th. So that's what we've got coming up. I'll stop sharing for a minute and see, are there any questions? Or we're seeing your computer screen. Okay, were you not seeing the Kelsey? Were they not seeing it?
No, we weren't. No, we can't see.
I can't hear you. Let's see here. Oh, probably. There we go. What now? They couldn't see it?
Yeah, we can't see your.
You can see your desktop on your computer, but not.
Okay, I didn't. That's a good practice. I didn't do it right.
The link I have on Zoom might even be the same meeting.
Let me see if I can do that again then. Make sure I can get this right. Let's see. Okay. Can you see it now?
Yep.
All right. Well, I got that right. So yeah, so here we go. So we'll go over this real quick. So here's today. Talk about ethical principles. And like I said, Rainey is going to talk with us on the 9th about mindfulness based treatments in substance abuse on the 9th, and then on the 16th, that presentation with Dr. Crawford and myself on harm reduction. So that'll close out this this fall semester. So all right, so that's better. Good. All right, so I'll stop sharing and put you all back in front of me. So we're going to talk about ethics, substance abuse treatment and ethics. So I'm fixing to try to share my screen again on that. And here we go. All right. Can you see the title page? Everybody see that? Thumbs up, Kelsey? See the title page? All right, good deal.
Yeah, we're good.
Good. So we're going to talk about substance abuse counseling and ethics. This will be the third part of this set of presentations. We'll talk next semester about supervision and ethics, but for counseling and ethics, this is part 3.
Did you
And we're
mean
gonna focus-
to say December 2nd, 2021?
It should say December 22. Yeah. So I'll fix that. Thanks. Thanks, Lenore. So we'll talk about HIPAA, confidentiality, and privacy today. So I want to go over this. So this caused me a lot of upset because I got some kind of pop-up. You all may remember a couple of weeks ago, there was this physician, OBGYN physician, who talked about a 10-year-old who had been raped and needed an abortion and was sent out of state. So hopefully you can see this. So what eventually transpired is the DA in I think it was a DA in Ohio asked her licensure board, the physician practice, to sanction her. And there were 2 things that came out of this. So one of them is related to HIPAA that we'll talk about. The reason for discussing this. One had to do with obviously this girl was raped and she was 10 years old, so there was child abuse involved. And so one of the questions was, did she report it in Indiana? Did she report it in Ohio? Did she need to report it in both places? That's really not what we're talking about today. But it probably does bring up something to think about if you're doing telemedicine from one state to the other, or if you're working with patients that cross state lines where there's some problem like this. But what we're talking really about today is down here. So the Attorney General's complaint asks the licensure board, that'd be the medical board, to impose appropriate disciplinary action, but doesn't specify the requested penalty. The state licensure board ensures physicians have the appropriate training and education to practice in the state and can suspend, revoke, or place on probation doctor's license. Now get this. Dr. Bernard violated the law. Her patient's trust and the standard for medical profession when she disclosed her patient's abuse, medical issues, and medical treatment to a reporter at an abortion rally to further her political agenda. Now get this. The office said in a statement, simply concealing the patient's name falls short of her legal and ethical duties. And so here we're talking about HIPAA, and we're talking about confidentiality, we're talking about trust, and we're talking about the therapeutic relationship. So we're going to talk about all 3 of those, but this is such a good example. I mean, as we'll go through the presentation, it'll become more clear. But I think, in a state, you talk about a 10-year-old who was raped and had to go out of state for abortion or DNC, whatever precision she had. It's probably, it's reasonable to believe that a good investigative reporter could probably figure out who that was in terms of who they are. And so that then becomes the critical issue. And we'll talk about this more in terms of HIPAA, privacy, and those kind of things. But the question is, you don't have to give somebody's name, but if you give enough details where it's reasonably, expected somebody could figure out who that is, then you've got a problem. So she didn't mention the girl's name or the family's name, but she may have well given enough details that she violated her duty to privacy. So that'll get us get us started. Interesting case. So remember, the last couple of times we've talked about the intersection between ethics, quality, compliance, and law. And we'll continue to frame this discussion up that way. Well, initially, we're going to talk about ethics, and then we're going to talk about quality, and then we're going to talk about compliance and the law. And these four things are ideas, as we've talked about in the past, support each other. So anyway, so here we go. So we're going to take a look at some links here, and then we're going to take a look at some codes of ethics and compare and contrast just a little bit about codes of ethics. So if we'll just start down here with Oklahoma counselors and see if we can get all this to work. And so if we go here to, this is the Oklahoma State Board of Licensed Alcohol and Drug Abuse Counselors. And we can go down here and we'll look at the Code of Ethics. This is a 2009 Code of Ethics. Don't think there's been much change. And one of the things you'll notice about the Oklahoma LADC Code of Ethics is pretty short compared to some of the others. And so we'll take a look at some of the others here in a minute. But you can see you've got E here, which is particularly, relevant to what we're talking about today. And this is an attestation that I certify that I've read, agree, and abide by Oklahoma Board LADC Code of Ethics. And so E here is I shall adhere to all the professional rules, confidentiality, and all maintenance and distribution of records, material knowledge concerning, client respect, so forth and so on. So that's a pretty succinct statement that covers a lot of ground for Oklahoma LADCs. But that's their statement. So if you're an LADC only, it might behoove you then to look at some of the other codes to see what they might have to say and kind of expand on that. So let's go. So we'll look at APA, American Psychological Association, and see what they have to say. Now, we looked at this before. This is the website. So you can see their code here is includes the 16 amendments, but you can see here it's broken down. They've got a preamble. They've got some introductory stuff. They've got general principles. We can look at those. And under these general principles, it's the benefits and non-maleficence, fidelity, responsibility, integrity, justice, and respect for people's rights and dignity. So they have this nice preamble. And then they have a whole section here on privacy and confidentiality. So psychologists are going to make statements about maintaining confidentiality, what's limited confidentiality. Psychologists discuss with persons, including to the extent possible, persons who are legally incapable of giving informed consent, and their legal representatives, the organizations with whom they establish scientific professional relationships. So there's some discussions about limits to confidentiality. Here's a nice one about recording, informed consent for recording voice or images. So if you were going to do some recording of a patient, it might be good to look at this in terms of the psychologist, APA, ideas about confidentiality. Minimize intrusions on privacy, disclosures. And so they have specific standards about disclosing fee and financial arrangements. Psychologists do a lot of consultations. So if you're doing consultation, you might want to take a look at this. So they have they have 6 or 7 large statements about privacy and confidentiality that kind of delineate some interesting things from a psychologist's perspective that would be important to know. So these ethical standards address it. Let's see here. The American Counseling Association, their code of ethics is in PDF form, but you can see they've got their various sections. And then section B is confidentiality and privacy. That's on page 6. They have some interesting points to be made. So here again, if you're trying to figure out what you need to do, your particular discipline doesn't have a real clear statement, maybe like the LADC. in Oklahoma, then you may need to consult this. So they're going to have a little introduction. They have these broken out into different sections. So they actually have a section here on sensitivity regarding cultural warnings, a cultural meaning, and confidentiality and privacy. So they take that. That's kind of unique. Explanation of limitations. And then they have a nice section here on confidentiality related to end-of-life decisions. Counsel supervised services to terminally ill individuals who are considering hastening their own deaths have the option to maintain confidentiality depending on the applicable laws, specific circumstances of the situation, and after seeking consultation or supervision from an appropriate professional legal party. So I think that's fairly unique to ACA. And then contagious and life-threatening diseases, they spell that out. I think that's kind of unique. Let's see here, client access, storage and disposal. Some states have rules on that, but minimum disclosure, a statement about that. And then statements about folks lacking capacity. I think this is one of the few. I did not look at AAMFT Code of Ethics, but I noticed that the counselors ACA does have a statement here about counseling couples and families. I think if you were doing couples and families and you needed to know or you should know about confidentiality laws, then you probably would consult AAMFT because they're the ones who do the families. I mean, I think they may have. Oh, yes, here it is. And if you were doing group work and you wanted to know what some guidelines on working with groups, confidentiality, privacy groups with families, then here's a statement here. So this is another code of ethics for the counselors, ACA, that would be important to know about and consult, particularly as you're practicing in different settings. Now then, we'll look lastly at the NASW Code of Ethics. And NASW, of course, they have these values and then these broad kind of ethical principles. So they got service, social justice, dignity and worth of the person, importance of human relationships, integrity. So a lot of these different kind of things touch on confidentiality and privacy. Then there's ethical responsibility to the clients, and this is where you find most of NASW social work clauses or conditions on privacy. So commitment to client, self-determination, then informed consent. So there's quite a bit of discussion here about informed consent, competency, cultural competency, conflicts of interest. And then you get 107 here is privacy and confidentiality. So they're going to talk about this now. Then, if you're talking, let's see here. There's a statement in here about here's families, couples, and groups. Here's a statement in here about known about the agencies, policies, confidentiality. Okay, and they're going to talk here about confidentiality related in legal procedures. Sometimes social workers are involved in child custody and those kind of things. So this month, if you're working in that arena, it might be good to look at what NASW has to say about those kinds of things. They have here again something workers' electronic communication storage systems. So they're talking about those kind of things. Access to record, and then they're talking about responsibilities to the client. So they're talking about privacy and confidentiality right along with access to records, dual relationships, sexual relationships, physical contact, payments. So they group them a little bit different. But of course, we don't have time today to, totally explore the different codes of ethics. But it'd be very important to take a look at those codes of ethics, have a general knowledge of them, and maybe have a copy or something access to as you get into areas where you need some clarification on privacy or confidentiality. So those are the ethical principles. Let's look at quality now. We tend to think about confidentiality and privacy and HIPAA and those kind of things as kind of legal thing that's kind of over here on this side, and maybe you don't connect it up to quality in terms of the relationship. So I went back and looked, and so the therapeutic alliance or the helping alliance or the working alliance is a long established kind of idea in psychotherapy and in counseling. And so there's this idea that a therapeutic alliance, and we'll talk more about that here in just a second, but a therapeutic alliance is strongly associated with positive therapy outcomes. So when there's a good alliance, working alliance, therapeutic alliance, however you want to call it, outcomes tend to be better. And it's a common factor. In other words, whether you're CBT, psychoanalytic, behaviorist, family therapy, that this positive working alliance or therapeutic alliance tends to cut across different types of therapy or different strategies or those kind of things. And if you think some about, motivational interviewing and some of those kind of things that are based on the relationship, it becomes pretty clear that a working or therapeutic alliance is very important. But it goes all the way back to Freud. So he called this serious interest or sympathetic understanding of the patient. So this is kind of this emotional, kind of relational connection with the patient. Rogers, of course, talked about unconditional positive regarding congruence and noted that outcomes in psychotherapy were highly correlated. So he talked about the therapist offered conditions, the talk of regard, empathy. So that's what the therapist offers in the therapeutic relationship, as Rogers saw it. And then the working alliance is composed of these three things: the bond, the goal, and the task, and they're highly correlated in outcomes. So what we're looking at today is this relational bond. And so the working alliance is really composed of these three components. So one is you got to have this connection with the patient. So the patient has to like you. You have to like the patient. The patient has to trust you. You have to understand the patient. The patient has to feel like things are secure and in the therapeutic relationship. So this whole idea of security, of confidentiality, of safety becomes really important in the whole idea of the relational bond. Secondly, you need to have agreement on what the goals are. In other words, what the purpose is. We'll not talk too much about that today. And then the third leg of the triangle is tasks. So there's a general agreement in terms of how we're going to get to those goals, whether they're going to lay on the couch and talk about whatever comes to mind, or actually do homework, or it's going to be a teaching kind of thing that the patient and the therapist agree on what the outcome is supposed to be, where they want to go, what this is supposed to accomplish, and that there's agreement on the task. And then the relational bond is kind of the glue, the cement, or the milieu that kind of holds that together. And of course, security, confidentiality, privacy is a big part of the relational bond. So here's a little bit more. So the bond is this network of positive personal attachments between the two, the therapist, the clinician, and the patient. And it's based on trust and acceptance and confidence. So you can see how confidentiality, security, privacy are all very, very important to what it is we do. And Haverthurst and Greenberg said, there's mutual liking. The client feels confident in the therapist's ability. The client feels the therapist appreciates them as a person, and there's this mutual trust. So the point here is that, sometimes you think about HIPAA getting a form signed. HIPAA is like, something that compliance people do. It's something that lawyers do. The whole security of information is very important to the therapeutic relationship, and so there then are compliance and laws that support that. So let's look at some of those now. So the HIPAA, as we call it, was enacted in 1996 and 2002, and there have been some updates to that. And basically, there's a couple of different facets of this. There's the privacy rule. That's what most of us are familiar with. There was also some rules on transaction and code setting, which most of us don't have anything to do with unless we're coders. There's a security rule that maybe some of us don't have anything to do with it. Maybe we ought to take a look at, particularly if we're in a small practice, we're in solo practice, and that is, do we have security for our computer systems or for our records? Then there's the idea of unique identifiers, and we'll talk about those in a minute. And then enforcement or breach notification rule. And that's what, if you have a breach, then what do you do about that? So we take a quick look at this just so you can see it. I don't know that you need to memorize it or anything, but it may be good to know. So this is an example, or this is the is public law 104, 191, 104th Congress, and so this is the act that kind of lays out the privacy, those kind of things. It talks about the difference between state law, if it's more stringent, trumps the federal law, and so some of the ideas. Let's see here. This is really kind of legalese kind of stuff, but this is what lays out the law for HIPAA. So it might be something you might or might not want to take a look at. There's what's probably more helpful for you is to take a look at a couple of things we'll look at here in a minute in terms of privacy and HIPAA. So what is PPI, private personal information? So this is from, I believe this is from any representation of information that permits the identity of an individual to whom the information applies to be reasonably inferred. So think back to our case. So here we are, we got a 10-year-old. I don't know how many 10-year-olds are sexually assaulted or raped in one state sent to another state. So either through direct or indirect means, it becomes possible to identify that person. So let's, this is DOL. So let's take a look here. And you can see, so this is the Department of Labor. This is a good example of one of the federal departments that outlines what personal private information is. And so you can see this is exactly the definition that we used. And so any combination of these data elements, and they would be a combination of gender, race, birth data, those kind of things. So you can see in this case that we were talking about how that becomes important. Even though the name wasn't used, there's a good chance that individual could be identified. So here are the HIPAA identifiers. So there's 18 of these. And so these are things that alone or in combination allow somebody to be identified. So obviously their name, it could be their address, that would be one. And all elements of dates except the year. So if you combine the year, the month, and the date, then that becomes an identifier. Telephone numbers, fax numbers, email address, obviously social security number, medical records number. I think this is one of the reasons, when we send emails, you don't put any of those kind of things about a patient in the subject line of an email. And health beneficiary plan numbers. So that would be another one. Any kind of account number, a certificate or a license number, vehicle identifiers, that would be both your driver's license number, it could be your tag number, those kind of things. So web URL, your internet protocol address, of course, your photograph, and any characteristic that could identify the individual. So any one of these or in combination of these, you could put that together and you could begin to identify the person. Would definitely be a HIPAA identifier. Now, when you use de-identified information for research, then these things are stripped out. And there's quite a bit of discussion in the literature here and there about how you go about doing that and those kind of things. So these are things to be aware of. These are the 18 identified HIPAA identifiers that should be avoided. Now, who's covered? So you're covered if you're a health plan. These are called covered entities, and so any covered entity has HIPAA responsibility. So a health plan would be your insurance plan. Healthcare providers, which are us. Healthcare clearinghouses like PPOs, those would also be kind of things, folks that maybe process insurance claims, medical insurance claims and those kind of things. And then any business associate or associate contracts. And this is kind of new from the original HIPAA, is originally with HIPAA, if I was a hospital and I contracted out with, let's say billing, or I was a practice and I contracted out with billing, then the billing had a breach, then I could say, well, that was the billing folks, and I didn't know anything about it. And later installments, what they've done is they come back and has had a business associate. So if you have a business associate, that would be anybody who takes out the trash. It could be who does your billing. It could be your custodial service. It could be it might be food care, bring food in if you have food served at your place and you have a caterer or something coming. So any of those kind of folks, so they now have to be a business associate, and you have to sign a business associate HIPAA confidentiality contract and agreement that says, yes, they're going to follow HIPAA rules and those kind of things. Or any associate contractors. This would be somebody be a 1 or 2 time contract. Maybe you're going to come in and do some consulting on computers or something like that for a hospital, or maybe you're going to come in and do that for a practice or something like that. You probably want an associate contract that says, yep, they understand HIPAA and they're going to abide by HIPAA. So, so the business associate is a relatively new piece of HIPAA. So, what are the exceptions? Because interestingly, we hear a lot about these kind of exceptions. So, what are permitted disclosures, or where the patient says yes, you can. You asked me, and I said you could disclose it. So, it could be for research. It could be for, in some cases, it might be for marketing. It might be for any of those kind of things. So that's where the patient actually gives consent, or to the individual. So if the individual asks for their record, then that's an exception. So there's some mental health guidelines on that. We'll talk about that here in a minute. But basically, if the patient themselves requests, then that's an exception. And then treatment. This is sometimes confusing. So I'll take substance abuse and kind of set it aside for the moment, but certainly for medical treatment and for behavioral health treatment, the treatment providers can consult with each other in terms of the care of the patient without having to get a release. Now, we go ahead and do that a lot, and that's not a bad idea. But if you had somebody who's in a crisis, who was having an acute situation, medical problem, psychiatric problem, or something like that, and you needed to talk to their primary care doctor, or you needed to talk to their psychiatrist, or you needed to talk to their counselor, whatever else, and it was on the behalf of the treatment, on the patient and part of their treatment, you'd probably be okay to go ahead and consult without consent. Although it'd be good to have a consent, but you probably could in terms of treatment or those kind of things. In terms of payment, so if somebody needs information, medical records about to get payment, then that is an exception. And then for healthcare operations, and that means that the people who are, filing the claims and working the claims on those kind of things, there's an exemption there. So those are really the 4 exemptions. We go ahead a lot of times and go ahead and get releases of information just to ensure that there's nothing wrong with that, and that's a good idea. But generally speaking, between providers, it's okay to talk if you're talking about the care of the patient, and you certainly wouldn't want to let a patient die, let a patient harm themselves, let a patient overdose or withdraw on something. Wouldn't it be very easy to have communication between providers to keep that from happening? So I did. Let's see here. So this is a website you should know. I mean, this is probably one you should bookmark. So this is hhs.gov. And this is probably one of the best ones that if you need a question or you need to know something about HIPAA, you need to know something about confidentiality, where things stand. This is a great web page to have marked so you can refer to it. So it's going to tell you, it'll tell you, what the initial Health Insurance Portability and Accountability Act was about in '96. Then they're going to talk to you about the privacy rule. That's the one that most of us know about. So if we click there, it'll give you the privacy rule. It's going to talk to you about the history, to give you a PDF, those modifications over the course of time. So those are, let's see if there's anything else. So that's the privacy rule. Then it'll also tell you about enforcement. the security rule. So this sets the rules of national standards for protecting the confidentiality, integrity, and availability of electronic medical records. So security privacy, I believe, is for all healthcare. Security rule is going to be for electronics. So if we take a look here, they'll tell you about what it is. You can look at the Federal Register if you want to. But a nice little HIPAA toolkit. How to do risk. That's kind of a new thing, is to assess your level of risk. So if you have, if you're a big practice or hospital and you have lots of servers and those kind of things, that's one kind of risk. Loss of electricity is another kind of risk. If you're a smaller practice and you carry everything on a laptop or you have it on a desktop computer, is it firewalled? Is it backed up? Those kind of things. So how would you assess your risk? And then how do you mitigate your risk through your compliance procedures? So that is an important piece there. And then you got enforcement. So this is about reporting, and this is about what happens if you do have a problem. So let's see here. Really 500, we could look in here, but 500 is kind of the mark. If you have a breach of over 500, that requires a little bit different and more immediate kind of action than if it's less than 500. That's a pretty good size number for most of us. But anyway, so that's the overview. And then you can go through and you can click these various things. So here's privacy. So we're just looking at that. So let's see, we'll just go look at guidance. Let's see here. Audio only telehealth. Talks about that. So it's the security. We looked at the security guidance. So we take a look here, talking about high tech in terms of this is going to be your electronic stuff and how best practices for security there. So physical standards, like these are going to be things that are your computer locked away. Do you lock the doors? If not, do you have logins for your employees, those kind of things. So if we click there, give you a PDF, and it talks to you about what is security. Security stands for physical safeguards, technical safeguards. So do you have firewalls? Do you have backups? Do you have those kinds of things? Very helpful. Physical technical safeguards is probably going to be things like passwords. It can be biometric kinds of things. And one of the things I want to know is if you're in a small or large practice, do you have training for folks so that they understand HIPAA? And then you've got this section we looked at on breaches and what you do there. Now, there's within compliance. So let's see here. Case examples. There's a couple in here that I think are probably worth noting. Let's go with healthcare providers and outpatient facilities. So here's one: outpatient mental health center corrects process for providing notice of privacy practice. So you look here, you can see mental health center corrects it. So this will give you a description of what went on there. And evidently, at least in one case, they were not providing notification of privacy practices. That's what you give at the beginning of a work when you give informed consent. What's the notification of privacy? And that patient will have to give consent in these circumstances. In these circumstances, consent may not be given. So that would be a good example of that one. There's a health science center. There's a couple more behavioral health ones down here, I believe. Outpatient surgical sanctioned private practices. I think here's one: private practice denied an individual access to the records on the basis that that portion of the individual's record is created by the physician not associated with the practice. So that's an interesting one. So you got a consultation or you had something else that was not part of that specific practice, and so they did not want to release it, although they should have. Let's see. Mental health center provides access and denial. So this is an interesting one. The complainant alleged that a mental health center, the center improperly provided her records to her auto insurance company and refused to provide her with a copy of her medical records. Center provided OCR with the valid authorization. So this is a good case where having it signed was a good thing because they were able to, Office of Civil Rights, who monitored HIPAA, they were able to show that they had an authorized, signed release of information for the auto company. But OCR also determined that the center denied the complainant's request for access because her therapist believed providing the record to her would likely cause substantial harm. The center did not, however, provide the complainant with the opportunity to have the denial reviewed as requested by the privacy rule. Okay. Among other corrective actions taken, So basically there, with mental health records, if you feel like it's going to be detrimental to the patient to see the record, you can deny it. While they, in this case, they released it to the auto insurance company, they failed to, or they decided not to release it to the patient, but then they failed to provide a review of her denial or let her challenge or have that denial reviewed. So here's another one. So you see mental health pops up here more than you might think. Complainant alleged that her mental health center, okay, I think that's the same one duplicated. So you can see that, see some examples of the kinds of things that behavioral health organizations sometimes get in trouble with. So the other thing I wanted to show you, and this is very, very helpful. So if you go to special topics over here, and you can see there's a lot of FERPAs on here and so forth. But if you go to mental health and substance abuse services, and then if you go down to helps, there's a lot of good information here. And you got opioids, you got minors, and then you got substance abuse. But I wanted to show you this. HIPAA helps mental health professionals prevent harm. So this is a PDF, and oops, that's not the one I was thinking of. Let's see. I think that was let me see. Let's just there's a questions and answers. I was just looking at this the other day. Here it is. So this is the one that is really good to have. So this is, like I said, Office of Civil Rights, who are the ones who enforce this. But you can see here, they're going to give you some background. This is specifically for mental health. This is HIPAA related to mental health. So this would be a good one to print off, have a copy of it so you can refer to it. So what it'll do is it'll have these questions here. Does HIPAA allow healthcare provider to communicate with the patient's family, friends, or other persons who are involved in the patient's care? And the answer is, let's see if I can make this a little bit bigger for you. So the answer is yes, in recognition of the integral role of family and friends. And so then it'll go on here and it'll describe for you kind of the parameters of that yes, and then it'll give you some PDFs you can use. Does HIPAA provide extra protection for mental health information compared to others? So yes, and so there's a description of that. So you can go on down here. When does mental illness or another mental health, another mental condition constitute incapacitation of the privacy rule? For example, what if a patient is experiencing temporary psychosis, intoxicated, and does not have the capacity to agree or object? So then it's going to give you a nice description of what you would do there with some additional notes. Can a minor child's doctor talk to the child's parents without the parents' mental health, about the patient's mental health status and needs? So this is a nice discussion here about that, and gives you some different cases. So this is it's not short, but it does bring up some good questions that we have from time to time about HIPAA, confidentiality, those kind of things. And mental health, specifically to mental health. If a law enforcement officer brings a patient to a hospital or other mental health facility to be placed on temporary psychiatric hold and request to be notified if or when the patient's released, can the facility make that notification? So that would be a good. So you can just see, we got a section on opiate use, substance use. So this is just a good thing to have access to emergency hospital in a dangerous situation. When does HIPAA apply? Allow doctor to notify the individual's family, friends, caregivers that the patient's overdosed because of opiates. So this is one that I would, you might want to get on here. You can get a PDF of this presentation if you think it's helpful. And you can get it from Kelsey, and you ought to be able to find those links and print that off. Now then, I think the last one we'll look at today is substance abuse treatment records, because substance abuse is kind of, a bird of its own. And so here you can find some fact sheets regarding substance abuse and confidentiality and frequently asked questions. So does a consent form allowing a program to disclose Part 2 information remain in effect when the disclosing program merges with another or undergoes a corporate restructuring? That's a very kind of good question. So Part 2 is going to be a treatment center that identifies themselves as a treatment center, substance abuse treatment center. So the idea being there that if you get it from the ABC, addiction program, then it's pretty reasonable to expect then that when you release that information, that you're letting that person that you release information to know that Mike has a substance abuse problem. Now, if you're from a program that is not designated specifically a substance abuse program, it's a mental health center, then you can release records because it's not identifiable that Mike is in a substance abuse program. So it gets a little bit dicey trying to figure out, some of this. So this is a great website to kind of parse some of that out, and it will help you understand whether you're a Part 2 program. Disclosure substance abuse disorder record. Does Part 2 apply to me? So this is a great one. And then, like I said, you can come down here and ask you these kind of various questions and give you some answers and information so you feel more confident in your response. So again, take a step back here. So this is HHS.gov, and then what they've done is they've pulled all this HIPAA for professionals, and they pulled it all together here with this special section on mental health, and that is right here, and that's a good one for you to have. So, all right, so that's kind of a quick review and some resources. So here again, we're going to follow up. We got a few minutes left. So we have ethics, and we looked at those ethics in terms of some different boards and different organizations and what those ethical standards were, what those ethical principles were as they relate to HIPAA confidentiality, particularly confidentiality and security. And then we looked at quality in terms of the therapeutic relationship and how security and privacy and trust and confidence is very important in what we do. So those ethical principles of security and privacy and trust support quality. So you can think about yourself. You'd be unlikely that, if you didn't trust somebody, you didn't think they were going to keep your information secure, then you wouldn't be able to have a good therapeutic relationship. And then, of course, that relates to what kind of work you're trying to do and what you're trying to accomplish in the means. And then we looked at compliance in terms of some websites, in terms of how you would establish good security HIPAA procedures that support that quality and that ethical idea of trust and security. And then there's laws above that. And we didn't spend much time looking at those laws today, but there are laws for breaches, and you get to pay a lot of money, and sometimes you go to jail. So with the 10 minutes or so we have left, questions or comments or ideas or cases or discussion? I'm going to stop sharing there and see if there were any questions or that was clear as mud. Or anyone else had anything else? I'll check the chat on here too. Okay. Yeah, I can probably place the link in this last link here. Let me copy that for you. Let me see if I can do this right. Oops. May not be able to. No, I can't do it. I'll get any other questions or comments? Vicki, you know a little bit about law. Any thoughts? Dr. Watt?
What'd you say?
I said, you know a little bit about the law. Any thoughts for your part on HIPAA and those kind of things? There we go.
No, but I like the reminder of the websites and the information you gave. I appreciate that. I felt that was, for myself, that was very helpful. Because it gives, I think it's succinct and I can go to that and look at it. Whereas sometimes I forget about that when I'm in a panic. And so I appreciate that information.
Yeah, good. I think I put it in the chat. So you should have the one on for mental health professionals. So you can go there. But yeah, I think it's really nice that they did that. So you can go there. You can look through there, see what your question gets close to their question, read what they have to say, get some clarification. At least before you'll talk to the attorney or your compliance person or the patient. You're trying to kind of explain what's going on. So I'm sure I didn't teach any new ideas today, but maybe links you up with some resources. Any other comments or questions? Any comments or questions about the case that we started with initially?
Well, I really like talking about that case because I think that can happen to anybody to start talking about a case in some situation and think that you're holding that person's confidentiality close and find out that you're not, because
Right.
just because you left out the name and that identifying information that you kept them confidential, but the information surrounding that case, it's kind of like when I was presenting that case in consultation about a month or so ago, questions that were asked about that patient's family, and we couldn't answer those questions because if we did, then it might identify who we were talking about. So, I think it's helpful to be reminded of that kind of stuff.
Yeah, we tend to think it's just somebody's name, but
Name and social security number and things like that. But I think we need to be reminded of that.
Yeah, strangely enough, I've had just a few cases where, if you said anything about it in the world, there's only one or two of these in the world. So, I mean, if you mentioned it, it was like anybody who knew anything about that time period in American history would know, oh, you're talking about. So you have to be very, very careful about those kind of things. Sometimes most people not, but I think, and I think, the other thing for me going through this again is, that whole HIPAA stuff, somebody get really aggravated at it and just sign the form and let's move on. But it's really rooted in a very, important dynamic of what we do. And that's security and that's confidentiality and that's trust. And so it's not like it's something that's disassociated from good practice. And I think that's important to kind of remember. So anybody else? Dr. Hilton, you got any comments? Dr. Fink or anybody else out there?
No, I think it was just a great, refresher for the group, especially around these politically charged issues. People can easily get ahead of themselves.
Yep. And that case is exactly about that. I mean, I don't know if she thought through what she was doing. It's and so many times, you know, we'll say, well, I know somebody, you know, and they remind, you know, and in that case, I mean, she just got way ahead of herself and found herself in real hot water. Yep.
Mhm.
Good deal. Good. All right. Well, if there's not anything else, I'll let anybody got anything else? I mean,
Nothing
But
for
this-
me. This was a great presentation. Thank you.
well, good. Thanks. Well, I think then we'll just go ahead and start the weekend of 3 minutes early, if that's okay with you all. No, we will see you next week, and Rain will be talking to us about mindfulness. So y'all take care. Have a good week. Thanks a lot.
Thank you, Dr. Brand.
You bet. Thank you.